Hello, good evening, and welcome to Unacademy. Welcome to the last session of the last lap. In yesterday's session, we quickly revised all the important articles of the Indian Constitution, and today in this last session, let's quickly revise all the important constitutional amendments. But again, what is the significance of the session? What is the utility of the session? I'll again, like yesterday, take you through some of the questions which have appeared in the prelims examination over the past few years so that you get an answer to your own question. What is the significance? What is the utility of this session? Let's get started and let's look at this question. Consider the following statements. This question was asked in 2022. A bill amending the Constitution requires prior recommendation of the President of India. Incorrect. When a constitution amendment bill is presented to the President of India, it is obligatory for the President of India to give his or her assent, which originally was not there, but the amendment which we will discuss today, the 24th Constitutional Amendment Act 1971, makes it obligatory, mandatory on the President to give assent to a constitutional amendment bill. The statement is correct. A constitution amendment bill must be passed by both the Lok Sabha and the Rajya Sabha by a special majority, and there is no provision for the joint sitting. This is also correct. 2 and 3B is the right answer, because a constitution amendment bill shall have to be passed by both houses of the parliament separately by special majority, and there is no such concept of a joint sitting when it comes to a constitutional amendment bill. Let's look at another question. Consider the following statements. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. Incorrect. A constitutional amendment bill can be introduced in either of the two houses of the parliament. It does not require the prior permission or the consent of the President of India. Can be introduced by a minister as well as by a private member. If such an amendment seeks to make changes in the federal character of the Constitution, the amendment also requires to be ratified by the legislature of all the states in India. Not all the states, not less than 1/2 of the states. The question is asking which of the statements given above is or are correct, neither one nor two. And please read the questions carefully. What if the question would have asked which of these statements are incorrect? Then C would have been the right answer. Please read the questions carefully. The 9th schedule was introduced in the Constitution of India during the Prime Ministership of, this question was asked in 2019. This 9th schedule was added by the first Constitutional Amendment Act in 1951. In 1951, who was the Prime Minister? Pandit Nehru. A is the right answer. This is how this topic becomes important for your examination. Now comes a factual part, and sometimes it's not Union Public Service Commission, it is Unpredictable Service Commission. Which principle among the following was added to the Directive Principles of State Policy by the 42nd Amendment to the Constitution? B. Participation of workers in the management of industries. Which of the schedules of the Constitution of India contains provisions regarding the anti-defection? D. 10th schedule is the right answer. This question was asked in 2023, although in the official answer key released by the UPSC has dropped this question, something unusual. But even if it was not dropped, the answer would have been, in India, which one of the following constitutional amendments was widely believed? And I think it's because of this phrase, widely believed, that the UPSC had to drop this question, because then subject to understanding kicks in. In India, which one of the following constitutional amendments was widely believed to have been enacted to overcome the judicial interpretations of fundamental rights? The answer should have been A, first constitutional amendment, because, and we will discuss this today. Let me not reveal the answer now. Clear? Now let's get started and understand all these important constitutional amendments. We'll start with the latest first. The last constitutional amendment which was done, the year was 2023, and it is called Constitution 106th Amendment Act. So total 106 amendments. And it is this constitutional amendment which talks about women's reservation in Lok Sabha, in legislative assemblies, in the Legislative Assembly of the National Capital Territory of Delhi, and then a separate law was enacted to extend this women's reservation to Puducherry and Jammu and Kashmir, two other union territories with a legislative assembly. Why? We don't have to go too deep into that. Let's quickly revise. And this constitutional amendment also talks about that there are seats reserved for SCs and STs. Even out of those seats reserved for STs, as nearly as maybe 1/3, so listen to me carefully, sometimes not less than 1/3 of the seats shall be reserved for women. But here the constitution says as nearly as maybe 1/3 of the seats in legislative assemblies in Lok Sabha shall be reserved for women, which means even if there are seats reserved for SCs and STs, even out of them 1/3 shall be reserved for the women belonging to SCs and STs. But that's one. Second, this Constitutional Amendment Act is not implemented. Why? Because there is a provision. The provision says this will come into effect after the exercise of delimitation. Once the delimitation exercise is carried out, which will be carried out after the census of, let's say, 2024 or 2025, whenever it is conducted, after that it will enter into force. And this law, a constitutional amendment, has a sunset clause as well. What is that sunset clause? That means the law itself says that this women's reservation shall expire after 15 years. From 15 years from the date of its commencement, this constitutional amendment, this women's reservation shall cease to exist. But this women's reservation can further be extended if Parliament enacts a law. So if the Parliament enacts a law, this women's reservation can be extended by a period beyond 15 years as well. Is that correct? Let's look at another list. And this is where we will club the two constitutional amendments. Instead of talking about 105, I will first talk about 102nd Constitutional Amendment Act 2018, and then we will discuss 105th Constitutional Amendment Act 2021, and I'll tell you the reason. We had National Commission for Scheduled Castes as a constitutional body, National Commission for the Scheduled Tribes as a constitutional body. Another constitutional body was created in 2018 called National Commission for Backward Classes under Article 338 capital B, because Article 338 talks about National Commission for the Scheduled Castes. Article 338 capital A, it talks about National Commission for the Scheduled Tribes, and 338 capital B talks about National Commission for the Backward Classes. Previously, this National Commission for Backward Classes, it was a statutory body. It was created by a parliamentary law, but then it was given a constitutional status in 2018. But then arose a controversy. What was the controversy? We have a central list of scheduled castes. We have a central list of scheduled tribes. Supreme Court thought that now if we have National Commission for Backward Classes, which means we will have a list of socially and educationally backward classes of citizens, this list should be common for all the states as well as the center. That means we should have one common list at the center for all the socially and educationally backward class of citizens, which means states and union territories will not have their own list of socially and educationally backward class of citizens. Ultimately, to rectify this, 105th Constitutional Amendment Act was passed. This was enacted to overturn the ruling of the Supreme Court, and now according to this Constitutional Amendment Act, every state as well as a union territory what they can do, they can pass a law. And through this law, what they can do, they can prepare and maintain a list of socially and educationally backward class of citizens. And this list may be different from the central list. So now this 105th Constitutional Amendment Act, it was enacted in the year 2021 to empower, to give power back to the states and union territories, that now you can have your own list of socially and educationally backward classes of citizens. That's the reason why I discussed 102nd and 105th Constitutional Amendment Act together. Clear? Let's look at something else. And before we proceed, here is a brief announcement for you. As I told you yesterday, if at all you are considering online live classes for your civil services preparation, if you're not considering now but may decide to consider at a later date, please consider this. And should you wish to enroll in these programs, this is the right time, because from tomorrow or day after, the course fee is going to be increased. Right now it is 30,000, less than 30,000 for a 15-month subscription. Now let's look at 104th Constitutional Amendment Act. Now the reservation for SCs and STs in Lok Sabha, in legislative assemblies, it was meant to be there for 10 years. But each time it was about to get expired, the reservation got extended by another 10 years, another 10 years, another 10 years. And this reservation, political reservation for SCs and STs in Lok Sabha and the state legislative assemblies, it was about to expire in 2020. But now, because of this 104th Constitutional Amendment Act, this reservation for SCs and STs got extended by another 10 years. That's number one. Number two, there used to be reservation for Anglo-Indians as well. If the president is satisfied that Anglo-Indian community is not sufficiently represented in Lok Sabha, the president could have nominated 2 Anglo-Indians to Lok Sabha. The governor could have nominated 1 Anglo-Indian to the Legislative Assembly. But this constitutional amendment, 104th, did not extend the reservation for Anglo-Indians. So reservation for Anglo-Indians as well as for SCs and STs was to expire in 2020. What the Parliament did in 2019, because of 104th Constitutional Amendment Act, it extended the reservation for another 10 years for SCs and STs, but did not extend the reservation for Anglo-Indians, which means now the Anglo-Indian reservation is gone. That's number 2. Number 3. That's why I've mentioned the statement. This act of the Parliament, after having been ratified by the legislature of not less than 1/2 of the states, which means to extend this reservation, you require ratification by the states as well, because you are providing reservation to them. Clear? Let's look at another constitutional amendment, 103rd Constitutional Amendment Act, which speaks about 10% reservation in educational institutions, in government jobs, for those belonging to economically weaker sections of the society, other than SCs, STs and OBCs, which basically means you are providing reservation to poor from the general category. So 103rd Constitutional Amendment Act 2019, it talks about giving 10% reservation to economically weaker sections of the society, other than those who are already getting reservation. That means those who are from SC, ST, OBC community, they will not get reservation, but this reservation is given to the members of the general category. Amongst them, whoever is poor, belonging to EWS category, they will get the reservation. And we also saw how last year the Supreme Court upheld this EWS reservation. Clear? Let's look at another Constitutional Amendment Act, 101st Constitutional Amendment Act 2016. And it is this Constitutional Amendment Act in 2016 which implemented goods and services tax in India, where centre also gave up some of its tax rights, states also gave up some of its tax rights, and ultimately this is considered to be one of the shining examples of cooperative federalism. And something that's cooperative federalism, we have borrowed from which constitution? Australian Constitution. And this 101st Constitutional Amendment Act also creates another constitutional body called Goods and Services Tax Council, GST Council, which is headed by the Union Minister for Finance. All the ministers of states of finance in the states, they are also part of it. So this is considered to be a beautiful example of cooperative federalism. Clear? 100th Constitutional Amendment Act, or 100th Constitutional Amendments Act 2015. And what it did, it legalized India-Bangladesh land boundary agreement. Some of the enclaves were exchanged. India gave up some of the enclaves, Bangladesh gave up some of her enclaves, and ultimately the exchange of these enclaves, that is what is called as the land boundary agreement between India and Bangladesh, which further cemented the relationship between the two countries. Although Teesta River is still a stumbling block in the relations between the two countries. But be that as it may, 100th Constitutional Amendment is related to the land boundary agreement between India and Bangladesh. So in match the following type questions, this can be important for your examination. 99th Constitutional Amendment created a constitutional body called NJAC, National Judicial Appointments Commission. So it was argued that the current system of judicial appointments, which is done by the president after getting the recommendations by the collegium system, that should be done away with, and we should have a different mechanism of appointing judges called NJAC, which would consist of Chief Justice of India, 2 senior judges of the Supreme Court, the Union Minister for Law and Justice, will have 2 eminent persons as well, and these 2 eminent persons will be chosen, will be selected by a committee, and this committee will consist of Prime Minister, Chief Justice of India, and leader of opposition or leader of the single largest party in Lok Sabha. But again, in the 4th judge's case, (2015), also known as the Sakara case, Supreme Court's Advocates on Records Association, what Supreme Court said, by the majority of 4:1, the Supreme Court said this NJAC is unconstitutional. Why? Because it violates basic structure of the Indian Constitution, which is independence of judiciary and primacy of Chief Justice of India in judicial appointments. It's also part of the basic structure of the Constitution, and that is why this 99th Amendment was declared unconstitutional. But be that as it may, let's look at 98th Constitutional Amendment Act. It added Article 371 capital J, which spoke of 6 backward districts of Hyderabad, Karnataka region. Known as the Kalyan Karnataka region, Raichur, Bidar, Gulbarga, Bellary, so on and so forth. Because Constitution says under Article 16 that there can be no discrimination when it comes to public employment on the grounds of residence. But Parliament can prescribe by law residence as a ground for getting a job, as a qualification for getting a job. But that is something only Parliament can prescribe. That too for state level posts, and that is something that you would know. And if you are a resident or a domicile of these 6 backward districts of Hyderabad, Karnataka region, you are eligible for government jobs in these regions. And for that, Constitution was amended. Article 371 capital J was inserted because of 98th Constitutional Amendment Act. The year was 2012. Then 97th Constitutional Amendment Act, which amended Article 19. The year was 2011. Because under Article 19, we have a fundamental right under Article 19, Clause 1, Clause C, which says that all the citizens, they will have the fundamental right to form unions, associations. And it was in 2011 that this word cooperative societies was added under Article 19(1)(c). Article 43(b) was added, which is under Directive Principles of State Policy, which talks about promotion of these cooperative societies. That was done by the 97th Constitutional Amendment Act 2011. Clear? Very good. Let's look at 96th Constitutional Amendment Act 2011. Although not that important, but I just wanted to tell you that even for changing the spelling or name, you require a constitutional amendment. And in 8th schedule of the Constitution, we have one language which used to be called Oriya, because the name of the state was Orissa. And the name of this language was replaced to Odia by this 96th Constitutional Amendment Act in 2011. Clear? And in fact, Odia was also given not through a constitutional amendment, but it was given the status of a classical language as well. And how many classical languages do we have? That's something that you can keep in mind. Kannada, Telugu, Malayalam, Tamil, Odia, we have 6 classical languages. Clear? Let's look at 93rd Constitutional Amendment Act 2005. There used to be a reservation for SCs and STs in educational institutions, although that is something which was done through a constitutional amendment, the first Constitutional Amendment Act 1951, but there was reservation for SCs and STs in educational institutions. Initially, it was for government educational institutions. And then the demand was that it should be extended to private institutions as well. Not just private, it should be extended to aided educational institutions which receive aid from the state, as well as unaided educational institutions, private educational institutions. And this was done by 93rd Constitutional Amendment Act, which says that the state can make provision for what? For advancing the socially and educationally backward classes of citizens, including SCs and STs, insofar as their admission to educational institutions is concerned. Whether this is a government educational institution or a private educational institution or an aided private institution or an unaided private institution, and the only category of educational institution which was kept out of this reservation system, that is the minority educational institution under Article 30 of the Constitution. And this was done by the 93rd Amendment Act 2005, an important constitutional amendment. Let's look at 91st Constitutional Amendment Act 2003. Article 75, which says the Prime Minister shall be appointed by the President, and all the other ministers shall be appointed by the President on the advice of the Prime Minister. But what would be the composition of this Council of Ministry? The composition of the Council of Ministry, the Council of Ministers, including the Prime Minister. The strength of the Council of Ministry, including the Prime Minister, shall not exceed 15% of the strength of the Lok Sabha. And this was done by, when Mr. Vajpayee was the Prime Minister, by the 91st Constitutional Amendment Act 2003. But at the same time, even the 10th schedule of the Constitution was amended, saying if there is a legislator who has been disqualified under the provisions of the 10th schedule, under the provisions of the anti-defection law, that person shall not be appointed to any remunerative political post. That means cannot be appointed to any post for which the money is paid by the government, is paid from the government revenue, is paid from the public exchequer, which means you can't be appointed as a minister. Yes, if you contest election again, you win the election again, then yes, you can be appointed to any remunerative political post, to a minister's post. But once you have been disqualified under 10th schedule, until the time you get elected back to the legislature, you will not be appointed to any remunerative political post. That is 91st Constitutional Amendment Act 2003. Clear? Let's look at another constitutional amendment. Remember, 102nd Constitutional Amendment Act created what? A constitutional body called National Commission for Backward Classes. Till 89th Amendment Act 2003, we had National Commission for Scheduled Castes and Scheduled Tribes as one constitutional entity. But the bifurcation was done in the year 2003 when Article 338 said we will have National Commission for the Scheduled Castes and a separate National Commission for Scheduled Tribes was created in 2003 because of 89th Constitutional Amendment Act. Article 338 capital A created a separate constitutional body called National Commission for Scheduled Tribes. Clear? Very good, Tanmay. 86th Amendment to the Indian Constitution 2002, which added Article 21 capital A to the Constitution. And it is this which created another fundamental right for all the children belonging to the age group of 6 to 14. Right to education as a fundamental right. It is the same constitutional amendment which amended Article 51 capital A clause K, which talks about a fundamental duty. The 11th fundamental duty was added by the 86th Constitutional Amendment Act, which now imposed a duty on the parent or the guardian that you have to ensure education to your ward in the age group of 6 to 14 years. And a directive principle was also rephrased, because previously this right to education was a directive principle. So it was a positive obligation on the state that you have to take steps to ensure education for all the children in the age group of 6 to 14 years. But now this directive principle became a fundamental right because of this amendment. And that directive principle, which spoke of education for the age group of 6 to 14 years, now it became a directive principle talking about early childhood care. In the age group of up to 6 years. These are the changes that were made to the Constitution under 86th Constitutional Amendment Act 2002. Clear? Very nice. Constitution 84th Amendment Act 2002. Now you would know something that we have discussed yesterday as well. After every census, there would be a delimitation exercise, which happened after the census of 51, after the census of 61, after the census of 71. But when the census exercise was carried out in 71, there was a delimitation exercise in 1973. This is where the southern states felt that we are at a political disadvantage. We are being penalized for doing good because we have implemented family planning programs effectively. The northern states are being favored for doing bad. They are given incentive for doing bad. And this is when the Constitution was amended, saying no further delimitation till 2000. This was done by the 42nd Constitutional Amendment Act. But then 84th Constitutional Amendment Act 2002 said, now no more delimitation, no further delimitation till 2026. So replacing this year 2000 with 2026, that was done by 84th Constitutional Amendment Act 2002. Clear? First, let's look at Constitution 77th Amendment Act 1995. And for that, you should recall Indira Sani judgment. And it is because of this Indira Sani judgment that Supreme Court said reservation for OBCs is constitutional, but reservation for poor is unconstitutional. Reservation can only be at the time of the entry. Reservation cannot be for promotion. So Indira Sani case 1992, it said there can be reservation but only at the level of the entry, at the time of the entry into a government job. The reservation cannot be at the time of the promotion. And to provide for reservation and promotion, for whom? For the members belonging to SC and ST community. 77th Constitutional Amendment Act was enacted in the year 1995 to provide for reservation and promotion for the members belonging to the SC and ST community. But there is no reservation and promotion for OBCs. That's something that you will have to keep in mind. Is that clear? Let's look at something else. Constitution 73rd Amendment and the 74th Amendment. 73rd Amendment deals with panchayats. 74th Amendment deals with urban local bodies or municipalities. 73rd Amendment also created what? 11th schedule which talks about functional items for the panchayats. For example, there are 29 items mentioned in the 11th schedule which talks about agriculture, rural development, so on and so forth. Similarly, in municipalities, 12th schedule got added which talks about 18 functional items. These 18 items should normally be entrusted with the municipalities. For example, cattle ponds, burial grounds, so on and so forth. All these items are mentioned in the 12th schedule. Clear? So 73rd Amendment deals with Panchayat, 74th Amendment 1993 deals with municipalities or urban local bodies. The Constitution's 61st Amendment Act 1988. Prior to this amendment, the voting age was 21. This voting age was reduced to 18 because of 61st Constitutional Amendment Act 1988 when Shri Rajiv Gandhi was the Prime Minister. Clear? Very good. Constitution 52nd Amendment Act 1985, and it is this Constitutional Amendment Act which added 10th schedule to the Constitution, and it is this 10th schedule of the Constitution which is known as the Anti-Defection Law. And who takes the decision on the disqualification of legislators when it comes to defection under the 10th schedule of the Constitution? That power is with the Speaker of the Lok Sabha. That power is with the Speaker of the Legislative Assembly. So this anti-defection law applies to Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, but it is this 10th schedule which does not apply to panchayats and municipalities, which does not apply to local bodies. But there have been various states which have been talking about, which have been making laws to extend anti-defection law to the local bodies. Deductivist is asking 52nd and 91st talks about anti-defection law. 52nd Amendment created 10th schedule, inserted 10th schedule into the Constitution, talks about anti-defection law, but this anti-defection law was further amended in 91st Constitutional Amendment Act 2003, where those who have been disqualified cannot be appointed to a remunerative political post. Clear? But what are the provisions of anti-defection law? A member of a house, and house is Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, a member of a house belonging to a political party, if you voluntarily resign from your party, you are disqualified. If an independent member of the house joins another political party after the election, disqualified. That is why the MP from Maharashtra, who previously was with the Congress, but then contested election as an independent, he has not joined Congress. He has extended support to the Congress party. If he joins Congress party, he will be disqualified. If you violate the whip issued by the political party, and that whip you have to keep in mind is a 3-line whip. Any legislator violating the 3-line whip shall be disqualified under the provisions of the 10th schedule. And a nominated member of a parliament, which means the nominated member of the Rajya Sabha or a nominated member to the Legislative Council, you can join a political party within 6 months of your nomination. If a nominated member joins a political party 6 months after the nomination, shall be disqualified under 10th schedule of the Constitution. Clear? Let's look at something else. The Constitution 42nd Amendment Act. Sir, but you're going reverse. We thought we're coming backwards from 2023 and then going back and back and back. So first we should have discussed 44th Constitutional Amendment Act 1978 instead of 42nd. But you will understand 44th if you have understood 42nd. Because basically 44th Amendment was done to nullify or to eradicate the massive changes which were made to the Constitution by the 42nd Constitutional Amendment Act. Clear? The Constitution 42nd Amendment Act 1976, and you should understand that this was the time when the country was in a state of emergency, which means Article 352 was in place. And this emergency was imposed on the grounds of internal disturbance. During this 42nd Constitutional Amendment Act, what changes were made? First and the foremost, preamble was amended. And when preamble was amended, which means the words socialist, secular, integrity of got added to the preamble. Clear? Fundamental rights and directive principles. It was this 42nd Constitutional Amendment Act which says if Parliament wants to enact a law to give effect to one or all DPSPs and in the process violates Articles 14, 19 and 31, merely on this ground, the law shall not be declared as unconstitutional. Which means this 42nd Constitutional Amendment Act tried to give primacy, superiority to all directive principles over three fundamental rights, 14, 19, 31. Article 39 capital A got added, which talks about equal justice and free legal aid. Something which we have discussed in the Conquer Prelims as well, where I spoke about Project 39A of the National Law University in Delhi. 43A, which talks about participation of workers in the management of the industries, which was the question which was asked in one of your prelims examinations, something that we discussed at the start. 48 capital A, protection and improvement of environment and safeguarding of forests and wildlife. This directive principle was also added because of the 42nd Amendment. And it is this 42nd Amendment which is known as the mini revision of the Constitution or a mini constitution. Fundamental duties. Part 4 capital A got added, dealing with Article 51 capital A, something that we discussed yesterday on the recommendations of the Sardar Swaran Singh Committee. That was also added to the Constitution because of this 42nd Constitutional Amendment Act. Other changes, Article 74, because Article 74 read, there shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, full stop. That's it. But it was this 42nd Amendment in 1976 which said there shall be a Council of Ministers with Prime Minister at the head to aid and advise the President, who shall act on that advice, making the advice tendered by the Council of Ministry to the President binding on the President. That was done by the 42nd Amendment. All India Judicial Service was created, which means Article 312. When Rajya Sabha passed a resolution by 2/3 of the members present and voting, then Parliament enacted a law, amended the Constitution, basically provided for all India Judicial Service. Tribunals were created, or Constitution was amended to provide for a chapter on tribunals. Article 323A, 323B, which talks about administrative tribunals and tribunals for other matters. That was also done by the 42nd Amendment. A lot of changes were made because of this constitutional amendment, but most of the important changes were these. These were the important changes. Also, the term of the Lok Sabha got extended to 6 years. The term of the Legislative Assembly got extended to 6 years instead of 5. So massive changes were made to the Constitution by the 42nd Amendment in 1976. Clear? Now, to understand the changes that got made because of the 42nd Amendment in 1976, some of these changes were undone by the 44th Amendment 1978. The first was Article 19(1)(f), which means one of the natural rights mentioned under Article 19 was acquisition and disposal of property under Article 19(1)(f). This was omitted. And in fact, because of 44th Constitutional Amendment Act, this right to property, which was previously a fundamental right, It was dropped from the list of fundamental rights. It became other constitutional right. Under which article? 300 capital A. Right? Article 22 also got amended, because under Article 22 we say whenever you are arrested, you should be informed of the grounds on which you are being arrested. And that's why when NewsClick founder editor was arrested, but he was not communicated the grounds of his arrest in a written format, the Supreme Court said this arrest is illegal, and that is how that founder editor of the NewsClick was released. But this protection, this Article 22 is a protection which comes to you after you have been arrested, which means once you have been arrested, you should be informed of the grounds of your arrest. You should be produced before the magistrate within 24 hours. But these protections are not available to those who are under preventive detention. But a safeguard was added by 44th Constitutional Amendment Act, which said that if there is a law which talks about preventive detention, but nobody can be kept in custody or can be detained under preventive detention laws for more than 3 months unless and until an advisory board is constituted. And unless and until this advisory board recommends further extension of such detention, only then can this preventive detention be extended beyond 3 months. Otherwise, no. So this safeguard was added by 44th Amendment 1978. Something else. Article 30, which talks about all minorities, whether based on language or religion, they will have the fundamental right to establish, manage, and administer educational institutions of your choice. But right to property got deleted as a fundamental right because of 44th Amendment 1978. But this right to property was kept intact for minority educational institutions, in a way that in making any law providing for the compulsory acquisition of any property of any educational institution established and administered by the minority. Can state acquire a private property? Yes. That's what we call doctrine of eminent domain. Yes, if it is for larger public good, the state can acquire the property of private individuals. In fact, right to property was deleted as a fundamental right. It only became a other constitutional right under Article 300 capital A. But Article 30 was amended to provide additional protection for those properties belonging to minority educational institution, saying even if you acquire this property, you have to give them compensation. And compensation should be such that it should not restrict or abrogate the right guaranteed by this clause. What does that mean? You want to acquire the property of a minority educational institution. For that, you have to give them compensation. But the compensation should not be too less, too small, that it will not let this minority educational institution to continue. So in a way, we can say that this right to property was retained as a fundamental right to minority educational institutions. Article 31 got omitted, deleted because of 44th Constitutional Amendment Act. Not just that, Article 38 got added. Another clause to Article 38 got added, which said the state shall, in particular, strive to minimize the inequalities of income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. This directive principle got added because of the 44th Amendment. Not just that, Article 74 got amended again. What was Article 74? There shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President. Full stop. 42nd Amendment says, who shall act on that advice? Now we had to redo what Parliament did in 1976. So in 1978, 44th Amendment said, provided the President may ask for reconsideration of that advice. But if the same advice is given again, it will be binding on the President to accept that advice. And there is one humorous explanation that I provide for this article in my classes, and I'll share that with you as well. When elections were announced in 1977, when Srimati Indira Gandhi provided for elections, basically called for elections, led to the dissolution of the Lok Sabha. Although it was considered to be something which people were not expecting, it was an unexpected decision. But nevertheless, elections were to be conducted and a coalition got created, the Janta Parivar as it was called. All the opposition parties, most of them decided to come together against Srimati Indira Gandhi. And they said, and they promised the people that we will undo the damage that was done to the constitution because of this 42nd Amendment. President also got happy. At least my powers will come back. And when Janta Party came to power, Shri Morarji Desai became the Prime Minister, Mr. Shanti Bhushan became the Minister of Law, and he introduced this 44th Constitutional Amendment. President was also happy, finally my power will come back. So it was maybe communicated to the President that we will restore your power, we will give you your power back. President was happy. And this is when this clause got added. Provided the President may ask for reconsideration of that advice and shall act according to the advice retendered. So this is where the President thought that this is cheating. In a way, although he didn't feel that way, we don't know, but to make you understand, we can say that the President felt cheated. In a sense, previously, if Prime Minister would have advised the President stand up, he would have said, why should I stand up? Your advice is not binding on me. But 42nd Amendment said, if the Prime Minister and Council of Ministers say stand up, as a President I can't do anything, I have to stand up. And 44th Amendment says, if the Prime Minister and Council of Ministers tells President, advise the President to stand up, the President may say, can I please sit? Okay, then President can sit. Stand up. Can the President say, please, can I just sit? No, stand up. The President has no other option but to stand up. So once he can send the matter back, but if the same advice is given back, it's binding on the President. That's how Article 74 was amended. Duration of the Lok Sabha, in fact the duration of the Legislative Assembly as well, which I told you that in 1976 got extended by a year. 6 years was the term of the Lok Sabha and the Legislative Assemblies. The duration got reversed to 5 years, both for state legislatures as well as the State Legislative Assembly as well as the Lok Sabha. Article 105. Remember Article 105, which talks about powers, privileges, immunities to the Parliament and members of the Parliament. Initially, prior to this amendment, Constitution said that all these powers, immunities and privileges should be defined by Parliament by a law. So all Parliament has to do, enact a law, and through this law, Parliament has to define what are these powers, immunities and privileges that will be available to Parliament and parliamentarians. But till the time Parliament enacts this law, all the privileges, immunities that are available to the British Parliament and the British parliamentarians shall extend to Indian Parliament as well as Indian parliamentarians as well. But then when Mr. Shanti Bhushan presented the 44th Constitutional Amendment Act in the Parliament, he said, why should an independent sovereign constitution refer to the constitution of another country? That is why this term, this reference to British Parliament was removed because of the 44th Amendment. 44th Amendment said all those powers, privileges, immunities which extended, which were applicable prior to the commencement of this constitutional amendment will continue. Prior to this constitutional amendment, what were the powers, privileges, immunities to Parliament and their parliamentarians? British privileges. Those privileges will continue. It's just that the reference to British Parliament got removed. That was done by 44th Amendment. Article 352. Massive changes because 42nd Amendment was made during national emergency. and to prevent further imposition or misuse, abuse, overuse, hyperuse of Article 352, Article 352 was amended. Now the term internal disturbance was replaced with armed rebellion. In fact, national emergency under Article 352 could have been imposed by the President and should have been approved by both houses of the Parliament by simple majority. That simple majority ratification got changed to special majority. It should have been approved by both houses of the Parliament within 2 months. Within 2 months got changed to 30 days or 1 month. Article 20 and 21 were exceptions. Exceptions in the sense, during national emergency, one by one, all fundamental rights could have been suspended, or the enforcement of these fundamental rights could have been suspended. But now 44th Amendment said, yes, all fundamental rights, their enforcement could be suspended except Article 20 and 21. And it is this 44th Amendment which provided for a special power under Article 352 Clause A to Lok Sabha. What Lok Sabha you can do? If you pass a resolution and this resolution is passed by simple majority, if you pass a resolution and this resolution is passed by simple majority, it is a statutory resolution and it is binding on the President to revoke national emergency. Clear? So these were, and there were other changes as well, but these were the broad changes that were made because of the 44th Constitutional Amendment Act. Clear? Now let's look at Constitution 25th Amendment Act 1971. Article 31 capital C was added, which said, if Parliament wants to enact a law, and through this law what Parliament wants to do? Give effect to two directive principles, 39B and 39C. And yesterday in the session we discussed what are these 39B and 39C. 39B, the ownership and control of material resources should be so distributed so as to subserve the common good. And 39B, the operation of the economic system should not result in the concentration of wealth and means of production to a common detriment. That means there should not be concentration of wealth. If Parliament wants to enact a law to give effect, to give shape to these two directive principles of state policy, and in the process fundamental rights under Article 14, 19 and 31 are getting violated, merely on this ground the law cannot be declared unconstitutional. Long story short, it was this 25th Constitutional Amendment Act 1971 which inserted Article 31 capital C to the Constitution, which gave primacy, which gave superiority to two directive principles, 39B and 39C, over three fundamental rights, 14, 19 and 31. And in fact, this amendment also said such a law cannot be even challenged in a court of law. There should not be any judicial review. But this part was struck down by the court in the landmark Keshavananda Bharti versus State of Kerala on 24th April 1973, where Supreme Court said Article 31C is okay. You can give superiority, primacy to two directive principles over three fundamental rights. But don't you dare say that there cannot be a judicial review, because judicial review is part of the basic structure of Indian Constitution. Clear? Although judicial review was not declare as part of the basic structure in Keshavnanda Bharti case. It was declared in the Minerva Mills case in 1980. Clear? Constitution 24th Amendment Act 1971. A beautiful amendment, or should we say an interesting amendment to the Constitution. And this was in the backdrop of the Golaknath case. Golaknath versus State of Punjab, 1967. What happened in this case? The Supreme Court said, in 11-judge bench of the Supreme Court said, fundamental rights are beyond the amending powers of the Parliament. The Government Attorney General said, sir, what about Article 368? It gives power to the Parliament to amend the Constitution. The Supreme Court said, no, it only talks about procedure for amendment. Look at the title of Article 368, procedure for amendment. It does not give you the power to amend the Constitution. The Attorney General said, sir, what about Article 13, which says that law is different, or our interpretation is law is different and a Constitutional Amendment Act is different. Because under Article 13, Clause 2, the state shall not enact any law to abridge, modify fundamental right. But for that, definition also is given under Article 13, Clause 3, which says law is rules, acts, notifications, bylaws, customs, usages, ordinances. It does not talk about a Constitutional Amendment Act. So through a Constitutional Amendment Act, we can make changes to fundamental rights. Supreme Court said, no, you can't do that. Because law means Constitutional Amendment Act as well. That means even using a Constitutional Amendment Act, you cannot modify, abridge fundamental rights. Fundamental rights, long story short, are beyond the amending powers of the Parliament. Srimati Indira Gandhi was the Prime Minister, not somebody who could take the defeat lying down. Got the Parliament together, amended the Constitution, 24th Constitutional Amendment Act 1971. And the first thing that the Parliament did was amend Article 13, which included Article 13, Clause 4 was added, inserted, which said nothing in this article shall apply to an amendment of the Constitution made under Article 368, which basically means law is different, Constitutional Amendment Act is different. Through a law, you cannot delete, modify fundamental right. Law means rules, regulations, acts, bylaws, customs, usages, ordinances. But through a Constitutional Amendment Act, you can. And if Article 368, the title was talking about procedure for amendment, even this title was changed because of this amendment. It said power of the Parliament to amend the Constitution and the procedure therefore. And another significant change was made. Any constitutional amendment bill passed by the Parliament, sent to the President, it is obligatory, it is mandatory on the President to give assent to a constitutional amendment bill. President cannot send the constitutional amendment bill back. President cannot use the veto. That was done by the 24th Constitutional Amendment Act, 1971. Clear? Let's look at another constitutional amendment. 7th Constitutional Amendment Act. Prior to 7th Constitutional Amendment Act, we had Part A, B, C, D territory. Part A included states which were previously governed during the British rule by the Governor General. For example, Madras, Bombay. Part B had territories which were princely states. For example, Hyderabad. For example, Jammu and Kashmir. For example, Mysore. Part C had territories which during the British rule were under the control of the chief commissioners. For example, Delhi, Coorg. And Part D had Andaman and Nicobar. This differentiation was done away with by 7th Constitutional Amendment Act 1956. And it was because of this 7th Constitutional Amendment Act that Article 153 also got amended. Because Article 153 talks about the appointment of the governor. The governor shall be appointed by the President. Right? But then same governor can be appointed to more than 2 states as well. This was provided by 7th Constitutional Amendment Act. Provides that there shall be a governor for each state, Since it may be desirable in certain circumstances to appoint a governor for 2 or more states, it is proposed to add a proviso to this article to remove any possible technical bar to such an appointment. Basically, this is part of the statement of objects and reasons. What is statement of objects and reasons? Normally, whenever a bill is introduced in the parliament, a document also is introduced by the minister called statement of objects and reasons. Basically, what is the objective of bringing about this law or this constitutional amendment? What do we want to achieve? What is the reason behind this? And the reason given was, since there is a possibility, it may be desirable in certain circumstances to appoint a governor for 2 or more states. That is why we need to amend Article 153 to remove any possible difficulty. Clear? Okay. Constitution 5th Amendment Act 1958. A proviso was added to Article 3. What is Article 3 basically? Article 3 gives power to the Parliament that you can enact a law, and through this law you can increase the area of a state, decrease the area of a state, alter the boundaries of the state, change the name of the state, bifurcate a state, merge 2 or more states. But a proviso was added in 1955 by the 5th Constitutional Amendment Act, which said basically a consultative process was included, which said if such a bill under Article 3, before it is introduced in the Parliament, it should be sent to the President for his prior consent. And before President can give his consent, President should refer this bill to the legislature of a state which is going to be affected by that bill, asking for the views of that state legislature. And it is only after those views are sought and received by the President within the possible time frame, then the President can give his assent, can give his concurrence, can give his permission, and then this bill can be introduced in the Parliament. Long story short, a bill under Article 3 cannot be introduced without the prior permission of the President of India. And before President can give his permission, the President has to consult the legislature of a state which is going to be affected by this bill. Which means if Uttar Pradesh is to be trifurcated tomorrow, split into 3 states, for that a bill is to be introduced in Parliament under Article 3. And such a bill cannot be introduced without the prior consent of the President. And the President can give his consent, but before that, President will have to refer this bill to the UP legislature, asking the views of the state legislature on this matter. Once those views are received, although those views are not binding on the President, but once those views are received, then the President can give his permission, the bill is introduced, and once the bill is passed by both houses of the Parliament by simple majority, then the matter is settled, the bill is passed, and it is sent to the President for signature. That was 5th Constitutional Amendment Act 1955. Now let's look at the last Constitutional Amendment Act, which is the first Constitutional Amendment Act, 1951. Changes were made to Article 15, and this was because of the impact of Champak Dorai Rajan judgment as well. The impact was because Land Reforms Act, Zamindari Abolition Act was declared unconstitutional by the judiciary. That's how first Constitutional Amendment Act in 1951 was enacted. In Champak Dorai Rajan case, the Madras government had issued an order saying we will reserve seats in educational institutions for SCs and STs. This matter was challenged in the court. The Supreme Court said in Champak Dorai Rajan case that this is unconstitutional. Why? Because it violates Article 15. Because Article 15 says there can be no discrimination on the grounds of caste. The government said that we are trying to give effect to Article 46 of the Constitution, which is a directive principle of state policy. Supreme Court said no, directive principles are inferior, fundamental rights are superior. And since this reservation policy of the Madras government was declared unconstitutional, Parliament got together, amended Article 15, inserted Article 15 Clause 4, which empowered the state that you can take steps for those who are socially and educationally backward, including members belonging to SC and ST community. Seats can be reserved for them in educational institutions. That was Article 15 Clause 4. Article 19 Clause 2 was also added, was also modified, because you have the freedom of speech and expression, but there can be restrictions on your freedom of speech and expression imposed by Article 19 Clause 2. And we have discussed in yesterday's session as well, or I think we discussed in one of the Hindu newspaper analysis a couple of days ago, where we spoke of Ramesh Thapar case, where a magazine was not allowed to be circulated into Madras because the allegation was if such a magazine is going to be circulated, distributed, it will lead to violation of public order. Supreme Court said no, this order that you can't circulate this magazine because it will lead to violation of public order. This order is unconstitutional because public order is not a ground on the basis of which your freedom of speech and expression can be restricted. But then Parliament got together and added public order as a reasonable restriction on freedom of speech and expression. Other changes were also made. Article 31 capital A, 31 capital B, 9th schedule got added to the Constitution. Which means if right to property at that time was a fundamental right, but if the government wants to acquire land, the government can acquire land, change the management of the factories for the better management of those factories. That could have been done under Article 31 capital A. And 31 capital B, it provided protection to certain laws. In a sense, just a second. In a sense, all laws which are placed in the ninth schedule was added to the Constitution. In a sense, all laws placed in ninth schedule, they were immune from judicial review. There won't be a judicial review. That's how agricultural laws related to land were placed in ninth schedule so that they are safe from judicial review. But it was later in Vaman Rao judgment, then again in I.R. Kolo judgment, that Supreme Court said all laws placed in ninth schedule before 24th April 1973, there cannot be a judicial review. But the laws placed after 24th April 1973, there can be a judicial review. Because it was on this date that a landmark 13-judge bench of the Supreme Court in a Keshavananda Bharti case said there is something called basic structure. And later on, Supreme Court said judicial review is part of the basic structure. So long story short, ninth schedule was added by the first Constitutional Amendment Act 1951. Any law placed in ninth schedule prior to 24th April 1973, prior to Keshavananda Bharti judgment, there can't be a judicial review. But the laws placed in the ninth schedule after 24th April 1973, there can be a judicial review because judicial review is part of the basic structure of the Indian Constitution. That is it that we had to discuss today. All the important constitutional amendment acts in one session relevant for the civil services examination. And from me and all of us at Unacademy IAS English, I wish all of you best of luck. Stay calm, stay safe, stay positive. If you remain positive, there is no power on earth that can stop you from doing good and doing well and doing spectacular on the 16th of June. Just keep calm. You have done all the hard work. Now is the time to reap the benefit of your hard work. Don't panic, because the real competition is in those 2 hours. Those who can control nerves will control the UPSC. So control your nerves, be confident. Best of luck, all the best. Good night.